Judge Ian Forrester is a judge of the General Court of the EU. He is a scholar, a teacher, a practitioner, and an author on a number of areas that are of interest to us: competition law, customs dumping, pharmaceuticals, sports, the precautionary principle, and human rights. He's also a member of at least by my count, 3 different bars: the Scottish Bar, the New York Bar, the English Bar, and he, in 1988, became Queen's Counsel. But the thing that I think distinguishes him most for our purposes is the fact that he's been involved in public interest lawyering for a very long time. Back in 1971, he was involved in helping to argue an appeal on behalf of the defendant, Louis Henry Burns, who the argument was that he was coerced into confessing falsely to a murder. And Judge Forrester was involved in helping to challenge that conviction. He is also the first head of White & Case's pro bono practice, and in that has received widespread recognition for the work that his firm has done. Judge, if you will, thank you.
Well, now, it's interesting that PILNet has invited 2 people who have had recent career changes. One of us has been on the bench for a very long time and then has returned to the private sector, and the other one has been a private practitioner for many years, and last year was sworn in as a freshly minted judge. And let me begin by a reflection about the process of being sworn in. I sit in the General Court of the European Union. That's the appellate court. The Court of Justice receives references and other things from national courts putting questions about European law. So it's the one that gets more targeted by newspaper criticism and political criticism. We handle appeals from actions of European institutions. But the same rituals apply to the swearing in. We have 23 working languages, official languages in Luxembourg. And so the new judge swears the oath in Irish or Greek or Latvian, or in my case, English. And there are representatives of the member states and gentlemen in morning dress and striped trousers, and it's all very grand and very splendid. And relatives look on with glowing pride, and it's very nice. In England, new judges wear extraordinary Father Christmas coloured outfits in crimson and white, and they promise that they will do right to all manner of people without fear or favour, affection or ill will. Now those words are splendid, and the circumstances are superb. The swearing in takes place in the Lord Chief Justice's court, and it's a very beautiful, very moving ceremony. One in Luxembourg is also interesting, but a bit different. And certainly the words in London are more moving. Without fear or favour, affection or ill will. Those are splendid words. Now, kings and ministers and governments, for centuries, as we've heard, have been interested in justice. It's part of what governments and kings are meant to deliver. It's called for by the Bible. And so there are many splendid instances of heads of state, kings, princes, governors, imposing upon judges, first of all creating judges, and then imposing upon judges the duty to be respectful of what we would now regard as basic principles. As you know, last year, Magna Carta had its 8th anniversary since being signed in 1215. And it went on a tour, the Hereford Cathedral copy, and happily the day that I was sworn in Luxembourg, Magna Carta turned up too. And so did ministers to come and have a look at Magna Carta. And the British ministers spoke with great skill and elegance about the contribution that Magna Carta had meant to subsequent generations, recognizing, of course, that Magna Carta was a self-interested document. The people who signed it wanted advantage for themselves, but that didn't detract from the consequences of the document for other people. Now, that's all lovely, that's all very good, and it's very nice that New York has judges like Judge Lippman. It's nice that the English judges swear such splendid oaths and so on. That's nice. But manifestly, it is not enough. You can have wonderful men and women serving in the role of judge, but you do not necessarily get justice. And so, access to justice for the poor, the inadequate, the immigrant, the person who's scared, the person who's illegal, the sans-papiers, those persons, the incompetents of our society, are maybe inspired by seeing a well-paid grand judge sitting on the bench in splendid robes. But what they need, as much as the theoretical presence of the excellent judge, is access to advice to help them to solve their daily problems. And the United States and the United Kingdom have a good record in great cases. Gideon versus Wainwright was a pro bono case. Don't Ask, Don't Tell was a pro bono case in which White and Case was involved. There are Obergefell and Hodges was another one, which have helped bring about important constitutional change. That's great. That really is great. But at the same time, there's the grunt work, the ever grinding daily challenge of delivering in a complex society where the rich get richer and the poor do not get richer, decent, clear, helpful advice for those who are distressed. Now, what governments do about that undeniable phenomenon is to recognize, there's obstacles. We regret those obstacles. I put it in the intransitive sense. Obstacles are regretted, and the obstacles are reinforced. Now, one example. I was speaking on Monday to an immigration judge who sits in the United Kingdom, and his job is to supervise judicial supervision, those words are accurate, of appeals by those who are denied permission to remain by the entry officer. So, the Afghan, the Syrian, the Moroccan, the American, the New Zealander is denied permission to remain by the appropriate person, by the public official. Skeptical, courteous, I hope, under severe instructions, and with a strict law. Now, in those circumstances, leave to appeal is necessary. That's to say, does this person have a stateable case? Is it worth an appeal? And in 10% of the cases, leave to appeal is granted. So, I'm fighting against you, but you can appeal. And in those cases, in order to go forward, the person who has been refused right to remain, but who has been found to have a stateable case, must pay £750. That's to get into the game. And each interlocutory motion that person introduces, Ting has a tariff of £300. So crowdfunding sometimes works. There's a lot of it. I mean, there's a lot of campaigns for individuals who look decent. And there was an Australian couple who resorted to crowdfunding, who were being deported was their word, but not refused permission to remain from the Scottish Island recently. They got crowdfunding. Generous lawyers sometimes can be found, but lawyers get nervous because immigration's special. We don't want to screw things up. And so we have the situation where a lawyer who isn't an expert might be willing to help, but is told by partners, you might make a mistake, you might make things worse. Of course they wouldn't make things worse, but professional responsibility being what it is, sometimes they feel they have to say no. Now, I sit in Luxembourg, and it's interesting at a time when European law is much criticized for being a source of interference with government. I think it's worth noting that European law, but not only European law, principally European law on this continent, has broken the monopoly of member states in creating rights. It is no longer the case that the individual rights of the individuals in this audience and the less fortunate people outside in the cold, it's no longer the case that those rights come only from governments. That monopoly has been broken. So, in those circumstances, I fear that it is public service which probably isn't offered much by architects, isn't offered very much by dentists, probably a little bit by doctors, but quite a lot by lawyers who maybe don't think of it as pro bono activity, especially in rural areas. It's just recognized. You can't expect to be fully paid by someone who doesn't have any money, but nonetheless you need to help them out. That used to be the tradition in rural areas where I come from. I hope that it still is true to a degree today. And it is obviously, all the more necessary because electoral phenomena in this continent and the United States in recent months have brought out the uglier side of humanity. And we have seen an increase in insults, in rudeness, in worse than rudeness, in assaults. We call it xenophobia. Maybe it is, maybe that's just a fancy word for disgusting rudeness to people who are different. Especially in those times, it's all the more necessary that we should remember the notions of public service, because we are indeed very privileged. One of my heroes is a German lawyer, South African parentage also, who was in the same chambers as me many years before in London. And his name was Heinrich James von Moltke. He had one German grandfather who was the great war hero, and the other was the Chief Justice of South Africa. So he was legally bilingual, and he had the possibility of living either as a successful lawyer at Two-Hare Court in London, rights, he chose to go back to Berlin to try to help in 38 or 39. And he ended up serving as the legal advisor to the Wehrmacht High Command. He was an expert in public international law. And he produced very accurate, very persuasive, and very inconvenient legal advice for his bosses. And he survived, amazingly, by recommending that the Geneva Convention required the protection of Russian prisoners of war, for example. And he wrote almost daily to his wife, who died just recently at the age of 100. He wrote to her on their ancestral estates. And one of his letters said that the voice of conscience may be lonely, even solitary, but often the speaker will not be the only one to think that way. The good example can often bring out a good reaction. Strange how infinitely many things suddenly turn on a single decision. Those are the few moments when one man can suddenly count in the history of the world. Everything before, everything that follows, is based on mass, anonymous forces and men. And then suddenly one feels that all these forces are holding their breath, and that the gigantic orchestra that's played so far has fallen silent for 1 or 2 bars to let the soloist set the tone for the next movement. It's only one heartbeat of time, but the one note, which will sound out alone and solitary, will establish the next moment, the next movement for the whole orchestra, and all await that tone. That was von Moltke to his wife. Von Moltke's luck did run out, and on the 25th of January 1945, he was judicially executed, the last English barrister to suffer that fate, so far as I know. Now, today, we don't risk anything worse than insults or grumpy partners when we do pro bono work. I see, Judge Littman called it pro bono as being a badge of honor. Yes, I see it. I would put it that pro bono is a tax upon success. Every decent lawyer, every decent legal practitioner who is a successful practice owes it to himself and to society, or herself, and to society, to devote a certain amount of time to work without compensation. And so, I end by saying, most people in this room, with 1 or 2 very few exceptions, are younger than me. And some of you may be looking for a job. So I say to you, if you're looking for a job, if you're interviewing a law firm, say to them, do you do pro bono? I'd like to do some too. It's really important to me. If you're a client looking for a lawyer, ask the candidate firm, do you do pro bono? That's important to my company. I want to hear about it. I want to tell our shareholders about it. And if you're a colleague of someone who does pro bono, and in my days as a practitioner, I had many colleagues who were colleagues of people who were doing pro bono. And I used to say to them, encourage, praise, don't disapprove. They'll work a bit harder, but you'll make just as much money. Don't worry. And finally, if you actually are doing pro bono yourself, I salute you. I look forward to hearing you argue in our court, and if you do, I hope you come and have coffee with me. Thank you.